So you received a suspension notice for your trademark application and you want to know what to do. This video is going to answer that question. My name is Derek Fahey. I'm a patent and IP attorney with the Plus IP firm. We handle a lot of trademark applications and we actually get a lot of suspension notices in certain cases. And whether or not you want to respond to a suspension notice actually makes a big difference. So first off, let's talk about what a suspension notice is. A suspension notice is a document that is issued from the US Trademark Office that says that when you filed your application, we did a search and we found another mark that's conflicting and that could prevent your mark from being registered on the registrar. So that's not good. Typically, you see those marks if they're very similar or confusingly similar, which is why we always recommend a trademark clearance search before actually filing a trademark application. So you get the suspension notice and you see the trademark application that's very close to your name and you need to think about, hey, what do I need to do? Well, first off, you have to understand that the examining attorney, when they issue the suspension notice, it's a lot easier for them to do that because many times they actually will issue the suspension notice and they'll say you don't need to respond when the actual application registers and become a registration, then the issue is now ripe and it will issue an office action, rejection or not. The problem with that is many times you're stuck in this limbo and you're waiting for months and sometimes even years until these applications run through the trademark process. And you may not want to wait years. You may actually want to get your trademark application registered. So a few things. First off, if the application that's currently pending is going to be going abandoned in a couple months, then you should think about that. If you see that the application will be abandoned, there's a few different ways you can do that. But let's say you see the application that's prior pending to your application, and you see it's going to go abandoned because someone didn't file certain documents, then you may actually want to wait until the application goes abandoned and then respond to the suspension notice. In other cases, you may actually see that the marks that the examining attorney cited are nothing like your application or your brand and you want to move it forward. Or even more importantly, let's say you're trying to file a lawsuit and you want to have those rights registered, the trademark registered, so you can have the benefits of a registration and the presumptions of the registration. You may actually don't want to wait. You want to respond now. In those particular cases, I find, and in my experience, I think it's very helpful for you to actually talk to the examining attorney when you file a response. Technically, the examining attorney, under the law, they don't have to file a substantive response. If your application is suspended and you respond, they can issue a suspension notice and just say, hey, this application is not ripe, I don't want to consider it. And they're allowed to do that. And sometimes the examining attorneys just will do that as not the easy way out, but the legally right thing to do that makes them have to do less work because they're really busy. So you need to take that into consideration. And I think examiner engagement is so important. If you see that you want to actually respond to the office action, you have really good arguments, I would suggest calling the examining attorney, and while they will always tell you they don't consider anything not in paper, explain to them the issues, explain to them if you have any litigation, explain to them that this application is going to be pending for years if you don't actually pick up the file and look and see the arguments. In some cases, I find that when you present good evidence in a response and you let the examining attorney know that you're going to do that and why it's important for him to pick up the file, maybe it's, hey, if you don't examine this mark is actually not even close to ours, and it's in this litigation that's been going on for a year and a half. The applicant may actually have to wait 2.5 years. I think it's important to let the examining attorney know that. They will take that into consideration. They may say no, but I really do think that they're human beings. They actually pay attention to what you say. And if you call somebody, the examining attorney, and tell him, hey, we're going to provide a response, or hey, this is not even close. Here's why it's not close. Here's the evidence about why it's not close and it won't be an issue. And you get that application moving forward. The examining attorneys will look at your response and then they'll decide either way if they want to sustain their rejection or sustain the suspension inquiry or not. So, if you get a suspension notice, I really think you should take into considerations where you are in the application process, and also if there's any litigation pending, how close the marks are, whether the decided marks or registrations may go abandoned soon, and think strategically about how you're going to respond. If you just sit there and not respond, you're going to have to wait for months, maybe even years before you actually get the mark registered, which may not be right for you or your client. So just something to think about when you receive a suspension notice. If you have any questions about how to actually respond, please feel free to reach out to us. You can find us online, Instagrams, all the socials. My name is Derek Fahey. If you could please like and subscribe the video. It really makes a difference for my family and my team's family. I'd really appreciate it. If you have any questions, just holler. Thanks for watching.